All right, I think I'll get started. In contract training, Steph and I like to zero in on issues with our contracts that we use on a daily basis. And we also take a clue from the phone calls that we normally get and see if there are things trending that we can address. Excuse me. A lot of people who sign on to contract training, I think mostly are newer agents or agents with an insatiable curiosity. So I appreciate that, but it's something that experienced agents, not many of us have the pleasure of going through a deal falling through. So when it is happening to you, you tend to forget what the process is and what the requirements are to make sure that it's enforceable and totally compliant. So that's why Steph and I like to talk about these things. So this is deal fell through and referred to as DFT. And these are the main reasons why a deal starts to fall apart. Obviously, the first main ones are the ones that have to deal with the contingencies in the offer. If a contingency isn't satisfied, that is a legitimate reason for the buyer who has marked these as a contingent, and that's exactly what the word means. The offer isn't fully executed or together until all the contingencies are satisfied. So by putting these contingencies in, and it turns out that these contingencies, one or more of them, cannot be satisfied, the buyer has a legitimate reason to back out of the contract, null and void the contract, and generally a legitimate reason for getting his earnest money back. So the most common reason, or most common contingency is, as you probably would guess, is the inspection contingency. There are so many doors opening and closing in an inspection contingency. You're dealing with the inspector's report, which now is hopefully been made simpler by now the inspectors have to list defects, where before buyers could make up their own defects. So that's been tightened up a little bit. But generally, we try to encourage your buyers. And if you're a listing agent, you try to encourage your sellers to negotiate the contingency before it does become unsatisfactory. So obviously the negotiations for the inspection contingency can be quite complicated. In the state of Illinois, lawyers do this, but in the state of Wisconsin, this is our job. And it's good to find a win-win situation for the seller and the buyer by using amendments to talk about what each party should be responsible for and what would be the outcome if they do, and when they should do it. So those amendment back and forth can go back and forth as many times as it takes. But if the gets to a point of a notice of defect, then you're saying that this contingency is a reason for the deal falling apart. And the steps that we have to go through to get that, you have to file a notice, you have to give a nod to the seller if they have right to cure. And that's the same in the appraisal contingency. If you select that, if the buyer selects that in the offer, their negotiation could go back and forth with amendments. But if it gets to a point where the buyer sends a notice saying the appraisal did not meet the purchase price, then the seller, if he has right to cure this appraisal, he can send a notice back saying that he will agree in one of the ways marked in the contract. So they give you many ways to negotiate these contingencies before they actually do kill the contract. Obviously, buyer's financing is a very important one, very important contingency. And I've heard a lot of phone calls when they come in, they say, but they had a really good pre-approval. How can their financing fall apart? And that happens, and it's not uncommon that that happens. If they have a great pre-approval and the lender said, oh, they're good as gold and all that stuff, there are still things that can come up that will notify the underwriter and give a red flag, and the underwriter will just say, we don't approve this loan. So making sure that all the bases are covered with you as a buyer's agent, with your buyer and the lender. Be very communicative with your buyer's lender. And if you're the listing agent, you should try to contact the lender as well to get updated. Some lenders will talk to you, some lenders will not. And then the final very important reason why deals fall apart, and this is what we're seeing more in today's market, being very competitive and highly, highly anxious and spontaneous, is buyer's remorse. There can be many offers on the table, and the buyer is compelled to want the house and want to price the house over what anybody else is, or drop all the contingencies or whatever. And then all of a sudden the buyer hits a wall and sees the reality and says, oh my God, I don't want to pay all this. And even though I don't have an appraisal or financing in there, I know I'm paying too much and I'm done. Another common buyer's remorse is literally in the first 2 or 3 days, even before they've turned in their earnest money. And they're just waking up in the middle of the night and saying, I don't want to buy this house. That's it. So if we go to the next slide, we talk about some of the other things that can happen as you're proceeding through the transaction that can break up a transaction. So besides buyer's remorse, besides the contingencies, these are ones that I've been listening to in the last couple of months, maybe 3 months. The seller is not curing the defects as he agreed to do in the contract. And it gets to the walkthrough or even before the walkthrough, and they find out that the seller said he cured the defects or said he will cure the defects if he has the right, and or whatever they agreed to in an amendment. And then they find out the seller's not curing them. Seller's arguing, oh, there's nothing wrong with that. Or I had my plumber in and he said there's not a problem and I'm not going to fix that. All of a sudden you've got a default in the contract where the seller had agreed to fix all these things and then they are not. Another unresolved issue that can threaten a transaction is the buyer, the seller not showing up at closing. In my most recent phone calls, this has happened. I've gotten 3 separate phone calls where the buyer didn't show or the seller didn't show, and now what? And it is a default of the contract, but now what becomes complicated. Another unresolved issue can be undisclosed problems with the property. Something comes up, a big rainstorm, or a tree falls on the house, or things like that. Either the seller knew about it or didn't know about it, but they are discovered before closing, but after the inspection. And those become issues that can be resolved, but sometimes are very difficult to resolve because usually it deals with a lot of money. And seller may not be able to afford that money, and the buyer cannot take on that responsibility, and the deal starts to tip. Another thing that I've seen happen, and it's really unfortunate, but there can develop in a transaction, one party not trusting the other party. He's lying, or he's just a money grabber, or he paid so much, he offered so much, and now he's trying to get that money back. And the buyer and the sellers start to create a big animosity with each other. And then unfortunately, sometimes the agents become complicit in this. And the listing agent starts blaming the selling agent, and or the buyer's agent and vice versa. And now the agents are at each other's throat and not trust each other and assuming all kinds of sinister things that the other broker is doing. Those things create such an atmosphere of distrust and negativity that it can literally break up a binding contract. Another thing that we deal with and that I've had phone calls about is we're trying to resolve issues and everything, but we're always running up to deadlines in this contract. And the deadlines become almost impossible to meet because of weather or conditions or whatever. And the other party will not agree to extend the deadlines. And so kind of stuck, you know, what are we going to do? Do we accept it as it is? Do we try to get out of the contract because they're not cooperating? So these are some of the lovely phone calls that I hear about, and we see that we have to help get resolved through this. Okay, so if the parties cannot agree to resolve these issues, now what? I mean, this is a time obviously to call Steph or to call me and get some help to make sure that you are in full knowledge of what the contract has said. You know, sometimes agents will call us and they really haven't even read what the contingency says, or they haven't read what the offer says. I mean, you really have to follow every single word in the contract to know where you stand. And there are many places in the contract, it tells you exactly where you stand if something isn't done. So it's your responsibility as the representing agent to know what the contract says, to know what these issues are and what happens if these issues are failing. So if these issues come up either through a contingency or through a default, first try to negotiate and put it in writing. Write it on amendments, even if you have to draft 5 amendments going one way and 5 amendments going back the other way. Keep the negotiation open as much as you can and do it in writing with the amendments. Don't do it verbally. Don't get a verbal agreement and then summarize it and put it in writing. Get everything as it's intended in writing on an amendment. But then there's sometimes you can do all these amendments back and forth and the parties still are not agreeing. The issue is too expensive. There's too much animosity between the parties, whatever it is, the negotiating fails and then we serve notice. And this is a very important thing because I think it's a detail that a lot of agents don't appreciate or realize. A notice to the offer to purchase must be sent to say why, within the terms of the contract's contingencies, the transaction must be terminated. So if it's terminating the appraisal, terminating the inspection, terminating the financing, there has to be a notice sent to say this offer is null and void because, and then you have to state why it is not being fulfilled, is not being satisfied. And then it depends in the contract wording whether the seller has a right to come back and negotiate. The seller has a right to cure. And the seller has to send a notice in return saying they either elect a cure or they're not going to elect a cure. And that's most common in the inspection and the appraisal contingencies. By giving the seller the right to cure, you're extending the life of the contract so that the seller, it's in his court to decide whether he keeps the contract alive or he doesn't. But with the notice, you must send proof of the contingencies failing. So you either send the appraisal report that shows it's low with that notice, or if it's financing was not satisfied, they can't fund it, then you have to send a letter from the lender denying loan approval. So the notice is not enough. It must be accompanied by the proof of it. Some agents just send the proof and not send the notice. They have to both be sent to the other party of why this deal is being terminated. So it's the notice to explain why, and then it's accompanied by the proof, either a letter or a notice of defects or whatever. And then if the seller doesn't have right to cure, then this deal is finalized. And the way to finalize it so nobody can sue anybody else, that's the release part. The cancellation part is canceling the contract totally and returning the earnest money to whoever agrees it should go to. If a contingency is not satisfied, then it's pretty obvious that the earnest money goes back to the buyer. And that's the way it reads in these contingencies. So if you read the contingency all the way through, you'll notice that if it cannot be satisfied, it goes back. Sometimes sellers are so mad that this contingency cannot be met, and they're really furious with the buyers that they'll just refuse to send the earnest money back, even though it's stated in the contract that the contingency is not satisfied and the buyer to have all monies returned. So these three things have to be included to actually kill a contract: the notice, the accompanied proof of the notice, and the cancellation and mutual release, or the CAMR, cancellation agreement and mutual release. Those three things make your cancellation binding, bulletproof. And if they're not, if they're missing the proof, or they're missing the notice, or they're not in agreement on where the earnest money should go, there's still going to be a lot of back and forth and issues, and sometimes lawyers come in. So if it's failing because of default, not because of contingencies, this is more of an argument. And on this page and in the next page, you'll see that I've inserted a very firm reminder that in these situations, you and I, compliance broker and agent, cannot be advising our clients on what they should do, or what they should say, or what they should write. That this is where a lawyer comes in, and a lawyer will determine the remedies for either party. So if it's not a part of the contingencies, if it's one of these things where deals won't close, there are still unfinished things that weren't finished, buyer's remorse, not showing up at closing, buyers and sellers won't speak to each other or speak to their agents, seen that happen, emergencies, and finding undisclosed defects after the inspection. So if the buyer is defaulting, these are the legal remedies, and this is actually in the contract. You don't have to be a lawyer to say this to your client. You can speak it, show it to them. If the buyer defaults, like buyer's remorse or something like that, and the buyer's pulling out, the seller can sue for specific performance and request the earnest money as partial payment of the purchase price. Or the seller may terminate the offer and either request the earnest money as liquidated damages or sue for actual damages. Now, you can show this to your client, but you can't really explain it to your client, because that gets into legal advice. So these are the remedies for a seller if the buyer is defaulting and not following through on the terms of the contract. This is what the seller can do, but then your role is to say to the seller, I think it's better if you consult with a lawyer on this. Now, I want to get into this because this pushback has happened many times. The seller doesn't want to contact a lawyer. The seller wants you to fix it. You're the one that got him into this situation. You're the one that better fix it. And you can't. But because the seller doesn't want to spend the money to hire a lawyer to get the paperwork done correctly, or the letter to be sent and suing or requesting the earnest money or things like that, you have to stand back and explain to your client, either your seller or your buyer, I cannot provide legal advice. I cannot be a lawyer for you. This you must do it. And as Carol Kriegbaum says, who's a very popular lawyer in our area, she said, I'm a hell of a lot cheaper than getting sued. So it's a nice way to say to your client, I think you better contact a lawyer because it's a hell of a lot cheaper than getting sued. So if we go to the next slide, this is what happens if the seller defaults. And the seller, like we just had a recent situation where the seller literally stood up at the closing, was mad because the agents on either side were not participating in giving him credit toward his commission. He wanted the agents to pony up part of the commission for him. And they said, no, it's not in writing. Nobody agreed to that. And the seller just stood up and walked out. I'm not selling. And so it's a phone call I get. And as I say, well, we're not lawyers. Your buyer is advised to contact a lawyer in this situation, but this agent and Steph or Kimmy or I cannot tell you what to do at this point, but other than seek legal counsel. So again, if the seller defaults, these are his options. He can sue for specific performance, or he can terminate the offer and request the return of the earnest money, sue for actual damages, or both. I had a situation like this happening where the buyer defaulted, didn't come to closing, was yelling at us, saying didn't like what we were providing or whatever. I've forgotten the reason, but he was kind of a jerk. He's from Chicago. He thought he knew better than anybody who lived in Milwaukee, including the seller and the agents, and said, I'm not coming to closing. And he didn't. So my seller, my client, sued for damages, actual damages. And the actual damages were, we put the house back on the market, got another offer, but of course it was lower than the first offer with this guy from Chicago. The damages were the difference in money between the first offer and the second offer. So say it was $50,000 less than the first offer, that was the amount of damages that my seller sued the buyer for. And he prevailed, he got it out of him. He also kept his earnest money. But again, this is where we get into legal situations where a lawyer is the best option for your client. Now, there's one exception to that. If there's an argument over earnest money, and I repeat this often when I'm talking to agents about arguments over earnest money. Say a buyer wants out because of a contingency that was not satisfied. In the contract, it says this can null and void the contract. If you show proof, send a cancellation agreement that the earnest money is coming back to the buyer. Seller's mad. Seller says, I'm not giving him his earnest money back. No way. I'm keeping it. I'm not signing this camera. I'm going to send my own camera over that says the earnest money goes back to me because I had to wait all this time. I've ordered the movers. I have damages, and I'm going to keep the earnest money. And sometimes we're talking about big earnest money, $50,000, $25,000. Which is pretty significant. This is a situation where your seller or your buyer, who's not getting his earnest money back, can go to small claims court. And this is one little loophole in the law that small claims court, generally, that's why it's called small claims, has a limit, has a ceiling limit on how much money we're talking about that's in dispute. And I forgot what the limit is. Some of you may know. But as far as earnest money disputes, there is no limit. So that's wonderful for us as an option for our clients. If it's a dispute over earnest money, to contact small claims court. The process is very simple. It usually costs about $200. Your client does not have to hire an attorney, just it's an appointment for a small claims court hearing, shows up with his documents. The other party can show up with their documents. And the judge who sits there in this room, sometimes it's a room with several judges and several complainants all sitting in this big room together, which is the situation that I was in. And the judge just looks at the documents or the proof on both sides and goes, well, you get your earnest money back. You have to pay the earnest money. And it's a court directed order and he has to pay it. So again, when it's a dispute over earnest money, try to go to the small claims court route, and then your client doesn't have to hire an attorney. If you're looking for names for attorneys, contact Steph or contact me, because we have a couple of attorneys that we recommend that are real estate attorneys. Make sure that it is a real estate attorney and not an estate attorney or a homicide attorney, or you want a real estate attorney, because I'll tell you, the other specialties may have taken one course in real estate law when they were getting their law degree, but they are not real estate experts. So because there's so many twists and turns in Wisconsin real estate law, and especially Wisconsin real estate law, we're different than most other states and some of the things that our state does enforce. And so it can't be just any attorney. You really need to get a real estate attorney to counsel your client, whether it's the buyer or the seller. So how do you stay out of all this mess? And you do it, it's basically when you're working with the buyer, it's one thing that we go over and over and over: buyer counseling, buyer consultation, before you ever even hit the streets, before you ever even look at a single room in a house. You have to have buyer consultation, and especially the process of an offer to purchase. You don't have to go through line by line of the offer to purchase all in one sitting, but you can take the sections of the offer to purchase, say over a period of a couple of meetings or 3 meetings, and explain what it means to you, Mr. Buyer. These are the benefits to you, Mr. Buyer. These are the protections to you, Mr. Buyer, but these are the cautions to you, Mr. Buyer. And having that earnest consultation with your buyer hopefully prevents buyer remorse and confusion and shock when you get to the inspection, denial when it gets to the financing, especially if it's VA or FHA financing. You've got to explain to your buyer ahead of time what the consequences can be from their choices. And this is where it was so frustrating for Stephanie and me during this highly competitive time of multiple offers and all of that, that we were getting our buyer and sellers, but mostly our buyer clients, to sacrifice a lot of these protections, inspection and financing and things like that. And it just scared me, because I've seen and heard so many stories of the consequences of not having a financing contingency or an appraisal, or having no inspection, and what the buyers have to sometimes unload on a house if they didn't have it inspected first. So buyer consultation is extremely important. Also, working with your seller, make sure that you explain to your seller what can happen. Talk to them about what an inspection is going to do if they haven't been through this process before. Talk about expectations, talk about disappointments that can happen. Tell them that an inspection sometimes will take 3 to 4 hours. I mean, That's something that we know and assume of a lot of time. It's not something the seller, understands unless they've sold before. Go through seller proceeds with your seller. They're great workshops or work forms. I think there's one in Command, I'm not sure, but I know title companies have worksheets on seller proceeds. It's vitally important when you are just listing a house to go over the seller proceeds with the seller. Make sure that they know before they get the inspection amendment or before they get the financing commitment, that they know what they are spending. They know that they're paying for title. They know that they're paying for certain things they may not know. Also go through the buyer costs with your buyer, the same thing. These are the costs you're going to incur when you buy a house in addition to the purchase price. Make sure the client understands the definition of defects prior to the inspection. Don't have that argument when the inspection report comes in. I mean, that's an awful conversation. Prepare them up ahead of time, looking at the seller condition report and the definition of defects of what to expect. You're not going to get a brand new house unless you're buying a brand new house, and then you're buying some defects that way too. But make sure that they understand what their expectations are in the house that they're buying. Another one, and this was something that we were seeing a lot in this highly competitive market, which hopefully is softening a little bit. Not the market, but the competition. Keep your relationship with the other agent very positive and professional. Always reply to them that you've received their documents. Always reply, thank you. Always, when you get an offer, thank them for the offer. Even if it's a really crappy offer, say, thank you, I'm glad you took the time to make this offer on my listing, and we'll get through this, or this may take some patience, but I'm sure we'll go to the closing table. Those kind of really positive, looking forward comments will keep the relationship between you and the other broker on a very professional level. Then maintain this relationship with your client as well. Don't let your client start to hate the other client. Don't let them start suspecting that they're lying or they're cheating or they're money grubbing or whatever. Don't create a negative perception on the other side. And a lot of times agents will do that basically to protect their own bottom, and they'll create an enemy in a sense of the other side to cover up something that they didn't do themselves. And it's really harmful. These things can terminate a very good deal that should have gone through, but because of personalities and because of animosity or attitude, these deals can fall apart. So that's my sort of overview, but I just want to say, if you're getting in a situation with a deal where it seems to be wobbling, either to inspection or financing or any of the default things that we've listed here, there are many others that can happen as a default, but call us, talk to us, talk it out, and maybe we can provide some verbiage or some suggestions in negotiating where you might be able to get through this. So, anybody have a good question or a regular question or simple question? But if you haven't gone through this, it's something that you probably should tuck this away to, because if you're in real estate, it'll hit you one time or another.
For sure.
And I've certainly been through a lot.
Any other general questions? No?
Nope. You remember, if you're in this situation, you want to terminate, you've got 3 things to send over. And I would say that's the most important message, because it's amazing how many experienced agents don't know that too. So. Okay, well, I'm going to give a shortened version of this at tomorrow's team meeting. But you got the longer version. And as I said, Steph and I are always here to answer your questions, whether about this or anything else in your contracts that you want.
Thank you, guys. Oh, we have a chat. Thanks, Shalina. Do you have any questions about what you're going through, or you just want to comment?
I right now am waiting on a loan commitment from the lender, and the listing agent reached out today and basically said if we don't have it today, we won't be able to extend closing because it's looking like nothing, the closing is scheduled for this Friday.
Okay.
So he's saying that it looks like we won't be able to close on time. The seller does not mind extending it, but they want to have that loan commitment. And I
And
don't
you,
always know that fine line between me calling the lender and getting on him versus the buyer getting on him. Because I don't want to overstep my place either, but I'm just like, can you please?
And you're the buyer's agent?
I'm the buyer's agent, and I always go over the details, the timeline. I send a timeline in the beginning, right after the accepted offer, letting them know. So they're watching this timeline. The buyers themselves are like, "Hey, shouldn't I have the
is the
loan
loan
commitment?"
commitment date passed?
No, it
It
hasn't. It hasn't.
hasn't.
It's very
Can
close.
you
Well,
get an
actually,
extension to close?
that's what he's saying is we're not willing, my seller is not willing to sign that if we don't have this in hand first.
Or is the
Okay.
seller willing to sign an extension for the loan commitment? The
Okay.
financing deadline. So we've got two possible extensions, one for the financing commitment contingency,
Okay.
which is going to be happening first, obviously, and then an extension of closing if that is needed. Will the seller sign an extension of the loan commitment deadline?
They have already signed that and they have not received it. So now we're teetering so close to closing. And honestly, what I believe is happening is the lender has so many clients that they're waiting until the last minute certain steps. That's what I'm saying. So after I get through a few more closings with this lender, I will not be using, it's a lot. It's a lot because I feel like I'm in the
Right.
middle in a sense. So,
Well, when you're talking about the fine line of what you should do, you and I have talked about this lender before. I
mhm.
think that you should contact him to get that loan commitment in, but also to see with the sellers that you can't extend closing. Because talk to the lender, but he's, as you said, not that good. You should be working with the listing agent to see if you can get, as Steph said, some extensions to push the closing back a little bit. If the sellers are still hanging there with your buyers, your loan commitment can come and go and the sellers can still keep the contract okay. It's just that after your loan commitment date has passed, the seller then has a unilateral right to end the contract anytime he wants. But
Yeah.
the most important thing is to see if you can get an extension on the loan commitment and an extension on the closing date to keep this deal alive. If the buyers want to buy and the sellers want to sell, they
Right.
should be able to, both parties should be able to extend.
Okay. Yeah, I
But
have
if
been
they
in
don't,
contact with
it's
the
going to
lender.
default.
Yeah, I have been in contact with the lender, and he's like, I promise, Shalina, I'm going to get it to you. I talked to him Saturday, so he's supposed to get it to me today. So I did talk to the listing agent and let him, knew that. He literally called me, the listing agent called me 18 times in a row. I was away from my phone and was doing an inspection. So it's, yeah, it's a tight situation, but I believe I'm handling it. But I'm literally like, I just got that call from the listing agent like maybe 15 minutes before I got on this. So it's just ironic that this is the subject today.
You're handling
Yeah.
it well. And remember, you can't control what the other party does, so that
Right.
that agent is just, you've communicated everything that you know. The timeline, the financing contingency has not come and gone yet. So, but I would not wait till 4:30 to call that lender if you don't receive the loan commitment today, or
No.
but I would call him by 4. He said by the end of the day, by the end of business day, I would call him at 4.
Yeah, I'm actually drafting an email now with both the lender and the listing agent on it, saying that I got this phone call, and just to make sure that we're all on the same page and that it's documented. Is that right to do?
Mhm.
And then follow up with the lender again, hey, we really need this today if at all possible, because he's refusing to sign any amendment for anything, is what the listing agent said to
Okay.
me.
Yeah, you gotta get it, because you gotta protect your buyer to be able to have the money to go to close.
Right.
So. And it's too late to switch. So
Right.
you gotta do with them. But I would, start being proactive. Maybe have you and your buyers draft an amendment to the sellers.
Okay.
Saying that, I think the best thing is just to extend the closing. If the lender's saying he's getting the loan commitment in, but you're saying the listing, he won't sign that until he has the loan commitment, right?
Yeah, and this is one of those, this is a FHA 203K loan.
Okay.
So initially the buyer didn't understand that she had to get quotes, even, simultaneously through the inspection period, get quotes on the work that needed to be done. And that took a little longer. And then the inspector had to come back in because the sellers didn't have certain things removed out of the basement, and the inspector couldn't get, they couldn't get to stuff. So there's been like a lot of that going on as
That's a
well.
lot of additional things, yes.
Yeah, and that's why we initially had to extend it. But now that we're at this point, he's just like, I need it now. So, yeah.
Okay, well, I know you're on the right track. Just gotta,
Okay.
but be firm. Don't be quiet.
Okay. I got
Okay.
you. I got you. Thank you guys so much.
Yes, of course. All right, any other questions? We like these kind of questions so that other people can hear other people's issues and how we respond to them. So. All right.
Okay, well, thank you for attending today. Really appreciate a good audience. So,
Yeah.
hope you learned something. And remember, these are all saved in the YouTube videos if you ever need to go back to them too.
Mhm. Thank you again, Joni.
Thank you, everybody.
Yes.
Thank you,
Bye.
Steph. Bye-bye.
Thank you.
Bye.
Bye.
Bye-bye.